The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. We have 3 cases that will be submitted today. Michael Merrill and Karen Jo Frescolin versus Valley View Swine and JBS Live Pork. We will have oral argument. That will be the first one this morning. We will then take a break from the bench for about 15 minutes, and we will reconvene for the second oral argument of Midwest One Bank versus Heartland Co-op. A third case will be submitted without oral argument, Cornelius Davis versus Iowa District Court for Scott County. That third case is submitted at this time. Are the attorneys ready for the Merrill case? Mr. Arato?
Yes, Your Honor.
Thank you. And Ms. Soul? Thank you. Mr. Arato, you may commence. You may begin.
May it please the Court, Counsel. Your Honors, we're here today on a primary question of whether costs can be awarded under Iowa Code Section 65711 when a plaintiff has voluntarily dismissed the action. A complete analysis today involves a look at not only 65711 but also 1.943 of the Rules of Civil Procedure as well as the Rules of Civil Procedure 1.413. The case involves important pillars of the law: jurisdiction, statutory interpretation, and stare decisis. I'd like to start with jurisdiction. The general rule, I think the parties agree, is that general jurisdiction ends when a party voluntarily dismisses the case. There is an exception to that rule, which is if there are motions pending or the court decides under Rule 413 of Civil Procedure that there has been a frivolous or bad filing, the court will retain jurisdiction for purposes of assessing costs or attorney's fees under that section. That's important in this case because the defendants did move for sanctions under 413 after the plaintiffs had dismissed, and the district court specifically denied that motion. That's not on appeal here now. So without a sanctions motion and with a voluntary dismissal, we would argue that there is no jurisdiction. Jurisdiction ends when a plaintiff voluntarily dismisses the plaintiff.
With the same rationale that we recognized continuing jurisdiction for the, I still want to call it Rule 11, but the sanctions rule, why wouldn't we apply the same reasoning to hold there's jurisdiction continues under 65711?
Because, Your Honor, 65711, and thank you for that because I was going to get into that distinction, 65711, we argue, is an award. It's an award statute. It's not a sanctions statute. The language of 65711 uses the words shall be liable and divests the district court of discretion as to what they are going to award. They must award all costs and expenses. As the court knows, any district court has the discretion to fashion a reasonable sanction, but when doing so, the court is looking to deter future behavior. It's not looking to compensate. And as we know from the intent of the legislature on 65711, the intent of the legislature is to promote and protect the CAFO industry. And so an award statute would do that. And so that is why jurisdiction still ends under 65711 because it's not a sanctions statute. It's an award statute. So no judgment, no sanctions, no jurisdiction.
Wouldn't that interpretation defeat the purpose of the statute? If the purpose of the statute is deterrence, to allow the plaintiff to initiate the action and then do 2 dismissals and cut off the district court's ability to actually enforce the statute, that seems to me that it wholly undermines the purpose as set forth in subsection 1 of the same section.
I would disagree because the statute requires first a losing cause of action and then frivolity, which is, I would argue, a pretty high standard to meet. Hopefully we don't see a lot of frivolous cases coming through. So the purpose of the statute is preserved by requiring simply first a judgment, some form of judgment, followed by a district court finding that the case was in fact frivolous.
But under your interpretation, the district court would be divested of the opportunity to even make a finding of frivolousness.
The industry would still be protected if the court felt that the case was frivolous. The court has the power to, on its own motion, enter sanctions under 413. However, as we discuss the interpretation of 657.11, I think it's clear that the statute requires first that there is a losing cause of action. Why? Well,
but doesn't, 413 maybe achieve a different purpose, because you could have a petition that is filed in good faith, and in fact this may be the case here, and then as discovery proceeds, facts emerge. For example, I don't think you knew at the time that Ms. Fresco no longer had an ownership interest in the land in question. I think I'm assuming you filed that on the assumption she did have an ownership interest in the land. And so as facts develop, then maybe continued pursuit of the action becomes frivolous, and then and therefore the statute maybe plays a different role from 413.
And then the court, I would agree that the court would then have a choice to make, because if learned counsel such as ourselves determines that this case is not going the right way, Shark versus Gorski, Smith versus Lally, Phipps, all those cases say, do not discourage a plaintiff from voluntarily dismissing the case at that point. As long as we are not within 10 days of trial, which the court would retain jurisdiction under 943. If we are within 10 days of trial, the court has the power to impose terms and conditions on the settlement. But if we're outside of that 10-day window, then stare decisis case law establishes that a plaintiff should never, ever be discouraged from voluntarily dismissing an action. Shark versus Gorski, and I'm not conceding anything here, but Shark versus Gorski goes so far as to say, even when the case is proven to be wholly without merit, allow the plaintiff to voluntarily dismiss, because that is what is in the best interest of judgment. I'd like to touch on the interpretation more of 657.11 and what it means to have a losing cause of action. The district court here applied 943, which I'll just refer to as the two dismissal rule, to say that constitutes a losing cause of action. We strongly disagree, and we think the case law supports our position. A second dismissal under 943, the words are, operates as an adjudication on the merits. Case law has interpreted the phrase on the merits to apply for res judicata and claim preclusion purposes, but says nothing about the actual merits of the case and whether it is a losing case or a winning case. Justice Waterman may remember from Smith versus Lally, when you have a form shopping plaintiff, that second dismissal comes down. It doesn't matter how good or bad the case is. The district court, actually in Smith versus Lally, the district court also said, we don't have jurisdiction to give you any relief. The case is over, but also a second dismissal says nothing on the merits. The case is simply over. My timer's not working. I don't know how much time I have left, but hopefully I still see a green light over there, so we'll keep going. Thank you. The defendants cite the CRST case, a case out of the Northern District, which uses a prevailing party analysis, which is not quite the same. Of course, in statutory interpretation, we use the language that the legislature actually used, not what they might have used. But even the CRST case seems to suggest that our position is the winning one, because CRST, when examining what a prevailing party is, says that there must be some sort of judicial stamp on the relative rights of the parties. And without that judicial stamp, without some sort of judgment altering the rights of the parties, there is no prevailing party. So when we have a voluntary dismissal, it's my Jerry Maguire moment, show me the judgment. Show me the judgment. Where was a judicial altercation of the rights of the parties? There wasn't any. They voluntarily dismissed, jurisdiction ends.
Then The statute just says losing party. It doesn't say party against whom a judgment was entered. It says losing party.
No, it says a losing cause of action. So what is
I stand corrected. Okay, losing cause of action.
A losing cause of action.
Yeah.
Sorry. So a losing cause of action, going back to Smith versus Lawley, does a voluntary dismissal say anything about the merits, about whether a plaintiff would have won or lost? No, it simply does not. It comes down to the issue of agency. The plaintiffs chose to say, we're going home. We don't want a resolution of our dispute. We're done. Iowa Rules of Civil Procedure say, that's okay. We'll let you do that, but you're not coming back again.
Doesn't it, the two dismissal rule has kind of an escape clause that it's an adjudication on the merits unless the court in the interest of justice provides otherwise. So could you have gone, or why didn't you go upon, as you're about to file the second dismissal? And I agree with you, we don't want to deter plaintiffs who want to give up a case for whatever reason from dismissing it, but could you have sought relief that some terms and conditions that this is, I don't know, if this is not we reserve our rights to, say this is not a losing cause of action under the CAFO statute or something like that. Could you have avoided this dilemma?
Could we have asked the district court? Yes, I don't think there'd be anything preventing us from doing that. If we were within 10 days of trial, I think we would be required to do that. But the language of 943 certainly doesn't require it, but we could. I would agree that we could have done that. We could have done that, but I don't think it would be in the best interest of our clients, because the 943 gives us the power to dismiss at any opportunity, and we don't want to give a defendant a chance to say, well, even though you're without.
Because the time is running out, could I shift gears to the question of whether the underlying causes of action were frivolous or not?
Yes.
And one question I have is, what's the standard of review? What standard do we apply to review Judge Szynski's determinations?
I would argue it's an interesting question because, of course, we're under 657.11, which would seem to be errors at law, but she's then making factual findings to determine the frivolity. So
normally we apply abuse of discretion to sanctions in other contexts. I understand your argument this isn't a sanction.
Correct.
But that would be the normal standard.
Correct. And it is an interesting question because it is applying, it's interpreting a statute, which would be for errors at law, but if there's factual findings, it would be an abuse of discretion, I suppose. We would argue still there was an abuse of discretion. This court, as well, some of you know, this is a sister case to the Hannah Michael versus Valley View case. And in that case, Michael Merrill's name comes up. And in that case, this court said both sides presented sufficient facts to survive a summary judgment motion. And at the time this district court turned around and found the claims to be frivolous, there was no additional record made. It was the same exact record. And this same district court had, in fact, denied the defendant's summary judgment and also found that the plaintiffs had presented sufficient factual evidence to proceed to a jury. I don't understand how that claim on the same record could then be found to be frivolous. As we put in our briefs, the frivolous, it's a difficult area because there's, like I said at the beginning, we don't see too many of them. The case law that we found suggests there's an objective and subjective element to a finding of whether a claim is frivolous or not. So we would argue that because of the record in the case, based on these facts of this case, the claims were not frivolous. It would be an abuse of discretion to find frivolity. It's also telling, I think, that the defendants moved for sanctions under 413, and the district court specifically denied that. And in the court's ruling on the facts, the court turned around and then relied on the allegations in the petition to find that it was frivolous. So I don't think that can be squared.
Are there any specific factual findings of the court that you take issue with?
I think we would take issue with all of the factual findings of the court, specifically the court's use of a single deposition of Karen Frescolin to interpret the mental attitude of her family members, which...
And I take your point about the subjective intent piece, but on the objective force of the claims, as I understand, the gist of the district court's ruling was that Mr. Merrill had fairly mild evidence and kind of undifferentiated evidence of smells and odors that couldn't really be attributed to any specific CAFO, and there wasn't a lot of evidence of odor as to him. Ms. Frescolin had a lot of evidence, but it was a property where she babysat, not a property that she owned. And that does strike me as a problem, since nuisance is essentially a property-based tort, not at its core. I mean, is the gist of those findings, is that incorrect?
The gist generally is correct, yes, as the record stood at the time of voluntary dismissal. The plaintiffs, on advice of counsel, dismissed the case voluntarily. I'm not here to tell you new facts or anything, but they were denied the chance to present any new facts. And they had already survived summary judgment. I see I'm out of time. Thank you.
Thank you. Ms. Soul, you may present your argument.
My name is Shannon. I'm here, although you cannot see, in the room with my co-counsel, Robert Gallup. I represent the court. I'm also here with counsel for Valley View Swine, for making As the court is aware, JDS and Valley have been before this court previously. The legislative intent of 65711 is to protect animal agriculture, shield them from the cost of nuisance. Those, as we can see by the listing of cases, are numerous. Not only are they numerous, they have been filed by plaintiffs, dismissed, refiled, litigated up until weeks or months before trial, and then dismissed. So, subsection 5 acts as a safety net for producers when a plaintiff is not kept from litigation via the gatekeeping function and is allowed to either pursue a frivolous claim through trial or through multiple dismissals. When that happens, 1.943 converts that dismissal to an adjudication. Converts the plaintiff to a person who brings the claim. When you look at what the term merit means, Iowa law allows us to look at the legislative intent of statutes. It allows children's statutes and other cases that have issues. And that is why defendants have raised the CRST versus EEOC. That case was actually an Iowa case decided by the United States Supreme Court, which the court looked at Title VII of the Civil Rights Act, which was a fee-shifting provision allowing attorneys fees for frivolous or groundless cases. In that case, the Supreme Court recognized that the significance is the alteration in the legal relationship of the parties. Plaintiffs have filed suit seeking some sort of damage or some sort of action against defendants. Defendant's position is that they wish for no action to be taken. And that is exactly, Your Honor, what has happened here. We have a situation where this plaintiff's second dismissal, plaintiff has not achieved any relief, and other defendants have secured
Miss Soul, can you hear me? Could you speak a little bit more directly into your phone? We can hear you, but it's kind of coming, yeah. We were recording this, and we want to make sure we have the best video we can. Thank you.
Yes, Your Honor. The situation that we're faced with, and that these state defendants were faced with in the division teaching, is a situation where a frivolous plaintiff is allowed to proceed all the way through trial, then have their case determined to be frivolous, which functions as a constitutional right to maintain a frivolous claim.
Ms. Soul, this is Justice Mansfield. I have a question for you. I'm following your argument. Let me tell you a question I have in reviewing the district court's order. Why is it that in this case the defendants get to charge to these two particular plaintiffs a percentage of costs that they would be incurring anyway in defending against other plaintiffs and indeed against another division or even another lawsuit? What's the rationale there? If the purpose of the statute is to make your clients whole for the additional costs that have been inflicted on them because of the frivolous claims, why do you get to do this cost sharing? It's possible that at the end of the day, some of the other plaintiffs will prevail and get a plaintiff's verdict, and then presumably a lot of these costs your clients would end up having to pay that they're already being charged to in part to these two particular plaintiffs. You follow my question?
Yes, Your Honor. And I would direct the court to the district court's entry of judgment and the defendant's submission of costs. Because these cases were consolidated, divisions A and C in this matter, the powder sheet case, for purposes of discovery, single depositions were taken for all three cases. What defendants have tried to do and what the court has granted as far as cost is an apportionment. So each of those depots has been divided, I guess, into three sections, one attributable to each case, then per plaintiff. We've narrowed it down to only this 1/9 of the bellwether plaintiff's portion of that damage. So these plaintiffs are being awarded a proportional fee.
But why is that?
Because arguably some portion of those depositions was taken in those other cases. And that sort of complicated math that the court and the parties undertook teases that apart. So plaintiffs are being held responsible for their portion of each of the expert depositions. These experts had to go on each individual plaintiff's properties and investigate them, take notes, take photographs. There was an individual component to all of this expert work that we now divided out so that plaintiffs are liable only for their portion.
Is that true of all of the costs that are being apportioned that there was in each of these depositions? They relate to somebody who did some amount of work specific to those two plaintiffs?
Yes, Your Honor. Plaintiffs all made the identical claims in the petitions that were filed. Plaintiffs claimed the same type of nuisance. They claimed the same damages in every single case. And none of those experts necessarily had to confront those allegations, which were uniform across the plaintiffs and required an investigation in each plaintiff's
Counsel, I have a question, Justice Waterman here. Is the district court's denial of the motion for sanctions under Rule 1.413 fatal to the claim for a cost award under the CAFO statute? Are they inconsistent?
Rule 1.413 has a component complaints when they had incurred no damage was in fact harassment, and evidence indicates from prior statements made by parties to this case, non-parties, that this was the intent. However, district court denied that. Without this intention, there can still be a lack of seriousness, a lack of substance to these cases, and that's exactly what we saw in the cases of Preston and Merrill. Plaintiffs who don't reside at the property for which they're making a claim, plaintiffs who reside in time, setback distance, these plaintiffs were not able to establish causation. They were not able to provide any kind of substantive or serious claims, and the court undertook a very thorough analysis of that. This district court and Judge Suzinski has been the judge on this matter since it was initially filed in 2013. We disagree that there's been any abuse of discretion based on the record and the complete record. Discovery had closed in this matter in September 2015. So no new information has been available to anyone. Yet, Mr. Merrill didn't dismiss until June 2016. Preston didn't dismiss until September 2018. So, Your Honors, we have a case in which plaintiffs, a full investigation of plaintiff's complaints was done. It was clear at the time of their depositions to both plaintiffs and counsel that these claims were without merit. But at that time, defendants are unable to do anything. They are simply at the mercy of plaintiffs to dismiss their claims. The plaintiffs had dismissed their claims in July 2015. Defendants wouldn't have had to undertake expert investigation into those claims. If they had been found frivolous, if they dismissed in 2015, the only cost, arguably, that they would be liable for would be the cost of their own deposition, such that this doesn't impose any kind of chilling effect. It doesn't encourage the plaintiff to maintain a frivolous suit. If anything, it forces the plaintiff to think long and hard before dismissing and refiling about the merits of their claim, and think about dismissal immediately when it becomes clear that that plaintiff does not have rights to stand on. I note, too, that while the statute imposes costs on plaintiffs for frivolous suits, it tries to make defendants whole, but can never truly do that. Here, the court denied attorney's fees, which are a tremendous portion of the work that defendants put into this case. So, to the extent plaintiffs argue that this award is burdensome, I encourage the court to consider the burden on defendants as a fraction of compensation that this actually provides to defendants. Briefly, I'd like to simply discuss plaintiffs' claim for attorney's fees. Here we argue that the court need not dive into this issue. Plaintiffs did not prove an error on this. The claim cannot be raised for the first time on appeal. Interpreted as a request for common law attorney fees, that standard, as articulated by the court, we're looking at oppressive conduct, conniving conduct, and it's simply not clear to defendants how filing a motion to recover some portion of costs incurred as a result of plaintiff's in any way oppressive or conniving behavior. Defendants cannot even be made fully whole. Because we're here
You may wrap up your thoughts.
I only have a few more seconds. If the court has no further questions,
Thank you, Ms. Soul. You may give your rebuttal.
Thank you, Your Honor. I would disagree with the defendant's position that they are forced to wait until trial to have 657.11 kick in. We would argue that 657.11 kicks in when a judgment occurs. That can occur, especially in this nuisance realm that we're in, after a GACI hearing. It could have occurred after a summary judgment hearing, but we won that summary judgment. It can occur during a motion to dismiss. But I do not think it was the intent of the legislature to completely broaden the definition of a losing cause of action to include a voluntary dismissal. I think we need a judgment. We do not have one here. But the idea that we have to go all the way through trial before the CAFO defendants can be protected under the statute, I don't think that's accurate. I think a judgment is sufficient. The idea that a voluntary dismissal means no relief has been achieved by the plaintiffs, that's particularly troubling as well in a nuisance action, because nuisances, as we know, may abate. What happens if a nuisance abates and there's no damages, no ongoing damages? And the plaintiff may decide, you know what, this was bad, it's not so bad anymore, there's still a year to trial, I don't want to do this anymore, I want to be done, because my recovery is not going to be worth the effort.
Yeah, let me ask you about the apportionment issue. There are, it looks like, pieces of maybe about 25 depositions that are being charged pro rata to Mr. Merrill and Ms. Fresco. In those depositions, was there questioning specific to Mr. Merrill and Ms. Fresco?
I wouldn't be able to speak to each and every one, but I'm going to say generally no, it wouldn't be a blanket truth that Merrill and Fresco appear in every one. I find the apportionment of costs highly troubling. It is, as the court pointed out, it essentially could amount to horse trading on costs, because there are plaintiffs that still pursued their actions and they could have won at district court, and then essentially Merrill and Fresco would be subsidizing part of the defendant's defense at that point.
What about the Stanley Consultants bill? Does that relate? Is there anything specific to in that? Because that's one of the major apportionment items that relates specifically to the two dismissed clients. I
apologize, I don't know that. I'm hesitant to speak to that because I don't know, and I don't want to make any misrepresentations. Stanley Consultants is generally, as I recall, deals with wind direction. I could be wrong, but I don't. Put it this way: Merrill and Fresco, Mr. Merrill and Ms. Fresco weren't the main focus of their report.
So, absent the apportionment of costs, how would costs be allocated to effectuate the intent of the statute?
The intent of the statute, if the claims were found to be frivolous, would be all costs and expenses, and I think I agree that the district court was faced with a difficult decision there, but to expand it to include all of those expert costs and all of those deposition costs, I think was overly broad, and I think.
What would be the alternative? The statute contemplates that these kinds of actions would generally be mass actions. That's kind of typical in these nuisance type cases. So is your position then none of the costs can be allocated because they're multi-plaintiff cases? Well, what's the answer for the district court?
I think in this case, based on the facts of this case, none of the costs can be allocated because the claims were not frivolous. Other than that, if, for example, there was a mass dismissal of all remaining plaintiffs, I would think the court would have to go through and decide which claims were frivolous and which weren't.
What about this principle, which I think I've seen before in other kind of sanctions litigation? That is, what the other side gets are the incremental costs that resulted from these two specific claims. So the incremental costs would be certainly your client's own depositions, and then any of these other costs relating to other witnesses that would be where additional time or expense could be attributed to the fact that these two individuals were in the case.
If it could be discerned that additional time or expense was needed because of these two frivolous claims, then that would be an equitable way to do it. But first, we'd have to find, one, that there's a frivolous claim, and we don't have that here. And I think also we need to find that there was a judgment, which there wasn't. And I see I'm out of time.
Thank you very much.
Thank you.
The matter of Merrill versus Valley View Swine is submitted to the court, and at this time we will take a approximately 15-minute recess from the bench. You may adjourn court right now.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.